In a medical malpractice case, if I have damaging information or damaging evidence against the doctor, am I going to use it to confront him during his pretrial questioning known as a deposition? Would you like to know the answer? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is, you bet I will. However, what you should know is that before I have an opportunity to go ahead and ask him questions about something damaging, let's say it is a hidden video or a video that my client obtained during a conversation with him in the hospital that he did not know about. And now I confront him with it by springing it on him as soon as I start questioning him. You know what's going to happen? His attorney is going to get very upset. His attorney is going to object. His attorney is going to yell and scream, or maybe not yell and scream, but certainly get very upset and say that he was never provided a copy of this and never had the opportunity to discuss this video with the doctor. Same thing with an audio recording that might be damaging to the doctor. And the reality is that if I intend on using it to question him during the course of this pretrial deposition, lawyers also call it an examination before trial, it would behoove me, meaning that I should exchange that with the defense before we actually start the deposition. Now you may say, what's the big deal? Give him the video, show him the video, and then after he's had a chance to see it and then talk to his attorney about it, now I can go ahead and ask him questions. Yes, that might solve one problem, but it won't excuse the fact that I had this video for a while, never exchanged it with the defense, never told them about it, and never gave them the opportunity to review it and discuss it in preparation for today's questioning. In that instance, what will likely happen, or what could happen, is the defense could turn around and object to my entire line of questioning surrounding what's contained on this video, and he might even go so far as to bust the deposition, which means that he would claim that the deposition is over, and now, in order for me to bring the doctor back at a later time, I'm now going to have to go to the judge and compel him to come back. And at that point, I guarantee you the defense attorney would turn around and say, hey, listen, Oginski had this damaging video beforehand. He never, ever shared it with us before. He knew about it. He failed to do it early enough to give us time to prepare for it. And because of that, you should now sanction Oginski for failing to disclose this information, and we shouldn't have to come back. I don't want to be in that position. The better practice is to go ahead and disclose that information. Let the defendants, let the doctor and his attorney see it, let them review it, let them talk about it, and now at the deposition, I can certainly ask the doctor lots of questions about it. Doctor, you're aware that my client recorded this video of you during this conversation, are you not? Yes, I am. And you learned about it a month ago, isn't that true? Yes. And you had an opportunity to review that video, isn't that true? Yes. You would agree that that is you on that video talking to my client, is that true? Yes. You didn't know that this video was being recorded, did you? No, I did not. Did you get permission for this video to be recorded? No, I did not. You're aware that my client was aware that this video was being recorded, correct? Yes. You're aware that my client consented to recording this video? Are you aware of that? No, I'm not. All right, doctor, let me ask you some questions about the information that you told my client during this conversation. And now I will go ahead and proceed to question the doctor and to confront the doctor. However, what you should know is that I'm going to use the video last. You might be wondering why I would not want to use that first at the very beginning of the deposition. Well, it's because I have an agenda, and I have to ask the doctor questions about his knowledge of the medicine. I have to find out if the doctor has a fundamental basic knowledge of the medicine involved in this case. And by doing that, I'll get a better understanding of what this doctor's level of competence was. If he can explain to me the basis for doing various tests and procedures, understanding the anatomy, and specifically things that went on in this particular case. Later on, I will get into hypothetical scenarios that if certain information was disclosed, or if certain information was known, would you agree that the outcome would likely have been different? And now I'll ask a whole series of hypothetical questions. After all that is done, I will then likely turn to the information that I'm going to confront the doctor with. Doctor, are you aware that my client made a video of your conversation that you and she had? Yes, I am. And you first learned about this video about a month ago, isn't that true? Yes. And you learned about that when I sent your attorney a copy of this video, is that correct? Yes. You did not give permission for this video to be done, correct? You did not know that my client was going ahead and taking a video, correct? Did you know that my client was in the middle of videotaping something that she was recording for her son? and now you happen to walk in? No, I was not aware of that. And were you aware that as my client was now talking to you, she had totally forgotten the fact that she had the video camera on and now her phone was still sitting there? You're aware of that, aren't you? No, I'm not aware of that. So why do I share this quick information with you? I share it with you just to show you what can happen if we have damaging information that I intend on using to confront the doctor during his pretrial question and answer session, and I don't disclose that to the doctor and his attorney before I begin my questioning. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter happened in the state of New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have an awesome day.